ನಮ್ಮ ಸೇರಿದ್ದು ಅಲ್ಲ ಅದು ಅವ್ನು ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ತಗೊಂಡು ಕೇಳಿಸುತ್ತೆ ಕೇಳಿಸುತ್ತೆ ಅಡಿಬಲ್ಲ ಇವ್ರೆ ಓಕೆ ಅದು ಪ್ರೋಗ್ರಾಮ್ ಶೆಡ್ಯೂಲ್ ಸರ್ ನೋಟ್ ಕಳಿಸಿದೆ ನೋಟ್ ಕಳಿಸಿ ಇನ್ನೂ ಇದೆ ಸರ್ ಬೇಕಾದ್ರೆ ಇದೆ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ ಸರ್ ಮಾಡಿ ಥ್ಯಾಂಕ್ಸ್ ಫಾರ್ ಕಮಿಂಗ್ ಸರ್ ಗುಡ್ ಈವ್ನಿಂಗ್ ಒನ್ ಆ್ಯಂಡ್ ಆಲ್ respected Honorable Vice Chancellor, Professor G. Hemant Kumar sir, Professor R. Shivappa sir, the Registrar, University of Mysore, Professor N.S. Srinivasulu, Professor of Law, National University of Juridical Sciences, Professor T.S. Somshekar, Professor of Economics, National Law School of India University, Bangalore, dear participants, my dear colleagues, PDF and PhD scholars, students, media friends, and other invitees. Sirs, so far we have conducted 3 webinars and this is the 4th one. First one was international webinar. 4 speakers from different parts of the world, including USA, participated in the webinar. For the same, we have received around 6,000 registrations and about 630 online viewers. The second one was national webinar and the resource persons were from Bangalore and Maharashtra, spoken on the subjects like econometrics and social sciences. Professor Madheshwaran, Director, ISAC, Bangalore, and the second speaker was Professor Yashwant Rao Jugale, Professor and Director from Maharashtra Shivaji University. We received about 400 registrations and 150 online viewers. The third webinar was on the current issues and economic development. Professor Bhanumurthy, Honorable Vice Chancellor, Bangalore Ambedkar School of Economics, delivered a lecture on COVID-19 and macroeconomic policy responses in India. And the second talk was by Professor R.S. Deshpande, former Director ISAC, spoke on the topic entitled Understanding the Genesis and Implications of New Farm Act. For the webinar, we have received about 450 registrations and 150 online viewers. Sirs, with your support and encouragement, we have planned the present one. For the current webinar, the main speakers are Professor N.S. Srinivasulu, Professor of Law, National University of Juridical Sciences, Kolkata. Professor will speak on the topic entitled Economic Analysis of Intellectual Property Law. And the second talk will be by Professor T.S. Somshekar, Professor of Economics, National Law School of India, University, Bangalore. He speaks on the topic Mobile Ecosystem and Competition Law in India. Both the resource persons, we heard that they are well versed in these respective subjects. Hopefully, they will be useful for the teachers, scholars, and students to enrich their knowledge. Sirs, for this webinar, we have received around 500 registrations and more than 100 online viewers. They are there. With this introductory comments, I call upon Dr. Navita Timmaya to welcome this August gathering for today's webinar and give brief introduction about the resource persons. Now, Dr. Navita.
Good evening all. It's indeed my privilege to welcome the August gathering to this evening. I welcome our Honorable Vice Chancellor of University of Mysore, Professor Hemant Kumar, who has been constant source of support and encouragement for organizing such academic events. I welcome you, sir. I welcome our Registrar, Professor I welcome our Registrar, Professor Shivappa, for gracing the event and supporting our academic endeavors. Welcome you, sir. A warm welcome to our resource persons, Professor Srinivasulu NS and Professor Somshekar TS, to this webinar. I welcome Professor Indumati S, former Vice Chancellor of Davangere University, who is there always with us in the department and supporting our endeavors, academic endeavors. Welcome you, madam. I welcome our chairperson, Professor Gopalappa, and a warm welcome to all our faculty members, Professor Mahesh, Professor Dinesh, Professor Basuraju, our guest faculties, our PDF scholars, our research scholars, and students. Welcome one and all. I welcome all our delegates, media persons to today's webinar who are participating and contributing to this webinar in making this webinar a success. Welcome one and all. So it's an honor to introduce the distinguished resource persons of today's webinar. Professor Srinivasulu NS is working as Professor of Law at National University of Juridical Sciences, Kolkata. Earlier, he was serving as faculty at National Law School of India University and also at our own University of Mysore. He is distinguished member of International Council of Jurists, London, Canadian Institution for International Law. He is associated with World Commission for Human Rights, London, and he had been invited as Max Planck Fellow at Max Planck Institute of Intellectual Property Rights, Germany, and he was also invited as Script Fellow, University of Edinburgh, Scotland. He has served as legal consultant for Government of West Bengal, Government of Karnataka, Government of Goa, Government of India on law and policy matters. He has guided 10 PhD students successfully, and he has to his credit 112 publications, including 7 books published from reputed publishers like Oxford University Press and Penguin Press, etc. And he has more than 70 research articles to his credit. It's indeed our privilege that you would be sharing your knowledge on economic analysis of intellectual property law. I welcome you again, Professor Srinivasulu NS, to this webinar. We have with us another distinguished professor, Professor T.S. Somshekar. He has over 20 years of teaching experience in the areas of law and economics, industrial organization, public policy analysis, and World Trade Organization. He has been an Erasmus Mundus Fellow at the Institute for Law and Economics at University of Hamburg, Germany in 2006, an advisor to the Ministry of Commerce and Industries, Government of Karnataka, to help formulate the industrial policy. A 2-time United States International Visitor Leadership Program participant. He is working presently at National Law School of India University. He was global visiting professor at Dedman School of Law, Southern Methodist University, Dallas for 5 years from 2011 to 2014. He has also been in Indian Council for Cultural Relations as chair professor at Sciences Po in Paris since 2011. He has produced research reports on competition law, issues in the commerce and high technology sectors. He is currently a member of the advisory board for the European Doctorate in Law and Economics. Thank you for accepting our invitation, sir, amidst your busy schedule, to be our resource person and delivering lecture on mobile ecosystem and competition law in India. I once again welcome you, sir.
Thank you, Dr. Navita.
Yes.
Now I request our Honorable Vice Chancellor to give inaugural speech. Sir.
Very good evening to you all. ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಪ್ರೊಫೆಸರ್ ಎನ್.ಎಸ್. ಶ್ರೀನಿವಾಸುಲು, ಡಾಕ್ಟರ್ ಟಿ.ಎಸ್. ಸೋಮಶೇಖರ್, ಪ್ರೊಫೆಸರ್ ಗೋಪಾಲಪ್ಪ, ಡಾಕ್ಟರ್ ನವಿತಾ ತಿಮ್ಮಯ್ಯ, ಪ್ರೊಫೆಸರ್ ಎಸ್. ಇಂದುಮತಿ, and Professor Mahesh, Dr. B.M. Basuraj, and M.V. Dinesh, and all the Professor R. Shivappa, my colleague, Registrar, University of Mysore. So today you have organized the seminar on law and economics. So at the right time, this seminar has been organized by this department. There are another more than 3-4 webinars have been organized by this. So this is one of the webinar which may be more useful. The law and economics is one of the most popular disciplines of studies in recent days. And it offers economics insights into the various aspects of both in theory and practice. Within the given legal framework, it explains how the economics efficiency can be achieved. In the law and economics, the general theories of law are viewed from the economic point of view. The legal theories are analyzed with the help of the economic tools. There is no doubt that one of the dominant theories of the jury precedence and the law and economics movement offers the general theory of law as well as the conceptual tool for the clarification and improvement of its practice. Law and economics offers a framework which into the model of the legal outcomes and the common objectives with which to unify disparate areas of the legal activity. The law and economics movements claims that law is the best understood and the tool to promote the economics efficiency. The criminal law, environmental law, etc., when examined with economic point of view, providing exciting and thought-provoking insights of the efficiency and social relations also. The combination of the legal theory and economic reasoning has created the new research agenda in the field of behavioral economics, how rationality affects the people's behavior with the legal scenario, and public choice theory, how collective behavior should have an effect on the legislation, and analyzing the game theory, that is strategic the action on the legal context, the economics of the crime and the punishment, etc. One interesting example of the law and economics can offer together the existence of monopolies, which often leads to the market failure and economic inefficiency. A situation where one party is able to extract more profit from a commodity than the healthy market would have allowed. The law can be used as a tool to ensure the monopoly situations and hard to rise and maintain. Another way of legal system can be used to ensure the economically efficient transactions. It is through the enforcement of valid contracts. So this, given the varied dimensions, relevance and academic significance of law and economics, it is good that the Department of Economics and Cooperation has organized this webinar. I'm very happy to inaugurate this. Let this webinar will come as a good proceeding. And Professor Srinivasalu and Dr. T.S. Somshekar is going to throw much light in the respective areas. I congratulate the faculties of all the faculties of this economics department who is actively doing this. All the viewers are viewing this. I think this will be useful for the for this law and economics students and also researchers. Thank you very much. Namaste.
Thank you, sir. Now I request the faculty members of the department to felicitate Professor Hemant Kumar, sir. Sir, I thank all the faculty members to felicitate Professor Hemant Kumar, sir. Now I request the Registrar, University of Mysore, to give some speech relating to the webinar. Sir.
Good evening, everybody. Once again, welcome to the national webinar on law and economics, which is organized by Dawson Economics and Cooperation, University of Mysore. And Honorable Vice Chancellor has inaugurated the seminar and set a correct platform to deliberate on this particular theme. And I know Professor N.S. Srinivasulu, who is from National University of Juridical Sciences, and Dr. T.S. Somshekar from National School of India University, Bangalore, would throw a light on this particular area. In my knowledge, there are two things. You are talking about economics and also law. One is markets, which speak on markets, and you study the market, and you don't know what is market and all, because the trend you can study. And the law is market is open. In my view, market is open and law is closed. Conceptually, I am talking about. So law is confined, closed, and within the definition you'll have to perceive. And markets are not like that. You'll have to read the trend and read the people's mindset, read the consumer's mindset, and think, think from all angles from a market's point of view. So you need a lot of vibrancy to understand the market forces. And the law as such, if you control market through law, there will be again further repercussions on the people's life and other things. So both are very important. Actually, this I don't know who has coined this particular two areas, and I think very relevant to understand in the present time being. So I think both these experts would throw light on this one. Definitely, if you look at it, the life from a legal angle, some of the parents I know, they don't allow, it is a very personal views, they don't allow their children to study law. Because if they if they allow their children to study law, it makes them confined to certain things only. That's why they are thinking that it's not going to give you a kind of creative atmosphere, open atmosphere to come up with their own talents, their own hidden talents or potentialities. That's why I think I learned that one. So law, if you study a law, you think only from a fixed angle. So you are not open, you are not creative, and if you think that you are going to do something against law. That's why the human potentialities are to be explored from all angles. That's why law is closed. That's why in that context I used it's a closed one, and it is a very confined one, very definite one. And whereas markets are open, and you study because people play with the markets. They play with the markets. That's why it has to be linked with this closed one and the open one. I think economists and also legal experts, both of them have to come together. How we should provide an environment to the general public, society, governments and all. They should throw a light on the policymakers and also politicians and economists, and also the public enterprises who are carrying out their own businesses and all. I think very good topic which the people have thought about. I wish all the best, and once again, as I join with our Honorable Vice Chancellor to congratulate the Department of Studies in Economics. We have taken all the efforts to organize this wonderful seminar. I see 162 people, 162 persons have logged in. I think even if you do offline, these many number may not come. But this is because COVID has provided this kind of atmosphere. So I think let us make useful, and also to see that these things are utilized. The technology is being used optimum level to reach out to the people. And either to Mysore University has organized several programs. Most of the science departments have organized, and also arts departments also have started doing this one. So I'm extremely happy as a registrar, and so we would like to encourage this kind of things. So the cost also would be less in organizing these webinars. So we will reach out more people, and also this is a more focused one. And you are not, viewers are not disturbed, and you are going to listen with all concentration. So you understand things and you jot down points, and also you put up your question in the chat box so that people can respond well. So very focused attempts are being done. So thanks to COVID from this angle. So once again, I congratulate our department, and please go ahead. And I think everybody is eager to listen to Professor N.S. Srinivasalu and also Dr. T.S. Somshekar. And in this kind of a wonderful webinar, Professor Indumati Madam, Honorable Vice Chancellor, who, has served in the Davangere University, is participating. She will throw a light on that one. And Dr. Navita Timmaya, Basuraju, and Dinesh, and also Mahesh, and Professor Gopalappa, and all our research scholars are participating in this one. And many stalwarts are there, they have logged in. So it's I wish a good learning exercise and knowing new things from this webinar series. Thank you. Thank you. Thanks for inviting me.
Thank you, sir. Thank you very much. Now I request again our faculty members to felicitate our registrar, Professor R. Shivappa, sir.
ಕಾಫಿ ಯಾರೋ ಹೋಯ್ತೀನಿ ನಂಗೆ 5:30ಗೆ ನಮ್ಮ ಪ್ರೋಗ್ರಾಮ್ ಇದೆ ಶುರು ಆಗ್ತಾ ಏನೋ ಕತೆ ಗೊತ್ತಿಲ್ಲ ಅದು
Now I request
ಶುರು ಆಗ್ಲಿ ಅವ್ರದ್ದು
Professor N.S. Srinivasalu,
ಮಾತಾಡಕ್ಕೆ ಶುರು
Professor of Law, National University of Judicial Sciences, Kolkata, to give his lecture. Sir, over.
Thank you. Thank you, sir. It's always a pleasure to speak on the invitation of my alma mater, University of Mysore. And thanks to the Department of Economics for arranging this program. And my special thanks to Dr. Navita Timmaya. Yeah. Am I audible now?
Minister bring a personal
Am I audible now?
Yes, sir. Yes, sir.
Yeah. Thank you.
ಇದು ಆಡಿಯೋ ಆಫ್ ಮಾಡಿ.
Thank you. Good evening to all of you. Ellargu namaskara. It's always pleasure for me to be part of my alma mater's activities, University of Mysore. And special thanks to Department of Economics today for arranging this program, webinar on the interface of law and economics. My special thanks goes to Dr. Navita Timmaya for not only coining this law and economics program, but as well for inviting me. Thanks to Professor Hemant Kumar sir, who is like my teacher since I know him from past 20 years. And Shivappa sir, the registrar, and also Indumati madam, whom I know from past 10 years through Professor Rangappa sir. And all the faculties of Department of Economics. Not my personal sake, but because my brother-in-law happened to be a student of Department of Economics. More than anything, as Shivappa sir pointed about some very interesting interplay between law and economics. So I take it from there and take you all through regarding what I would like to speak on this aspect of law and economics. It goes without saying that law is never divided up in any discipline. Law doesn't come on its own. Law is not going to come from blue. Law making always depends upon some movement, some euphoria. Sometimes lawmaking depends upon political reasons. Sometimes lawmaking depends upon social reasons. Sometimes on economic reasons. So lawmaking is always dependent on the society. The various activities, various movements that take place in the society that drive the making of law, execution of law, and as well interpretation of law by the judiciary as well. So we have three organs of law as such: the legislature, the parliament or assembly, whatever you call, the executive, the cabinet, ministers, prime minister, chief minister, and all, and as well judiciary, both at national level and the state level. So all these three different organs of law or law establishment depend their execution, depend their interpretation of law based upon the movements that take place in the society or activities that drive the society. There are days when lawmaking was influenced by industrialization or labor movements. During the British times, I'm talking about the colonial times, pre-independence time. During that time, lawmaking was completely influenced by industry and labor issues. Because as we all know that British Raj or British government happened to get established in India when Britishers came basically for the purpose of business through their established East India Company. So the rapid industrialization, whatever they intended to have in India only for their own people or their own entrepreneurs, reduced Indians into labor. So industry from Britain, labor from India. So the tussle between British industry and Indian labor resulted in a number of movements, including freedom movement, as we know. So that movement of the tussle between industry and labor resulted in number of legislations to be made, number of laws to be passed, even during the time of pre-independence. Number of legislations reading the labor movement. Of course, the International Labour Organization also pitched in this context because Britishers not only captured India, India was not only Britishers' colony, entire world was Britishers' colony, including USA, Europe, and a number of such continents or nations. Such being the case, entire world was actually at the footprints of Britishers, and the Britishers wanted to convert entire world into their industrial zone to sell their products and make all those people who are into their colonies, like India, to be their laborers. So this tussle, this capturing of market, this capturing of nations by Britishers, and reducing those respective nations and domestic people as labor, resulted in bringing out of a number of laws and legislations, both at international level through International Labour Organization and at national level through the respective state, local, and national governments. Number of legislations like Industrial Disputes Act, Workmen Compensation Act, Employees State Insurance Act, Factories Act, and as such, number of such industry regulation, I don't say market regulation, industrial regulation, and ensuring some amount of labor welfare through trade unionism, workmen compensation, minimum wages, employee state insurance, like this to balance the industrialization with that of labor issues. Number of such legislations happened to come out during that time. So that was the era when industry and labor dominated the field of lawmaking. Aftermath of independence, during 1950s and 60s, human rights movements that have taken place both at international and national level influenced lawmaking, especially Universal Declaration of Human Rights of 1948, International Covenants on Political Civil Rights, International Covenant on Economic Rights, Cultural Rights dominated the league, and during 1960s and 70s, most of the laws that we made in India as well happened to be under the influence of human rights movements that have dominated the scene. By virtue of that, even if you look at the Indian Constitution as well, one particular block or one particular section has been completely reserved for human rights issues under the Constitution of India. That was the great amount of influence that the human rights movement at the international level and as well national level had on the lawmaking process, not only at international level but at national level. Number of legislations were made or existing legislations were amended under the influence of such human rights movement in 60s, 50s and 60s. Aftermath of that, during 1970s and 80s, environment related issues, public issues happened to dominate or drive the lawmaking process. Bhopal gas tragedy, Sriram gas tragedy at national level, such other serious environmentally affecting movements at international level dominated the scene and influenced lawmaking. During that point of time also, number of laws were made to protect environment, to protect environment, to regulate environmental damage, And to ensure public interest and public safety during 70s and 80s, in India also, 1986 Environment Protection Act happened to, we happen to have it. So the point that I'm trying to say is 70s and 80s dominated in the lawmaking process with the movements and influence of environmental issues. Then comes economics. Economic perspectives or economic movements that have taken place during 90s. In particular, World Trade Organizations coming to be reducing entire world into single market, global market, international market, whatever you call it as. So that movement of World Trade Organization happened to influence lawmaking process since 1994 till now. I'm not saying that earlier to 1994 economics or economic viability, economic interest was not dominating or what was not influencing lawmaking. It was, but that happened to be at a great level aftermath of 1994, because in 1995 World Trade Organization came into being, resulting the entire world into single global market. The emergence of World Trade Organization also didn't happen in a day, in a month, or in a year. About 5 decades, international society happened to put its efforts together, ranging from 1947 till 1994. About 5 decades, 8 different phases of negotiations between and amongst international players, 1947 to 1994, culminated into the establishment of World Trade Organization, which happened to rapidly change the thinking of people, thinking of international society, and the way we perceive market forces, market influence, market presence, and market regulation as such from the frontiers of law. Not only at international level, aftermath of the coming into being of this World Trade Organization, wherein more than 20 international laws happen to get established aftermath of or during the time of this particular World Trade Organization's emergence, but as well at a national level also, every piece of law happened to be getting influenced by this economic institution, or the institution which drives the economies in one go across the globe. Yeah, it's true. The World Trade Organization is driving not just any one or two economics, all the 215 nations' economics in single go, because it is the World Trade Organization which can be said to be the real government now, because what you export, what you import, which industry you would like to establish, what type of consumer discount you are giving, what type of subsidy you are giving to farmers, in what way you are promoting students, in what way you are encouraging investment, everything is under the control of a World Trade Organization. That's why people from legal frontiers today speak about the relevance, serious relevance of national governments. Where is the concept of sovereignty, republic, the recently celebrated Republic Day? Where is the relevance of this republicanism, democratism, or sovereignty when we have given complete control of our market to this international organization called World Trade Organization? That is in a way, pessimistic argument or classical argument from the frontiers of law. But the international society has accepted that. More than 175 nations have accepted to this particular international market regulator called World Trade Organization, and all the nations are now, if not on other matters, on economic matters, are under the clutches and control of this World Trade Organization. The interesting point is that it has reduced entire world into single market. Anybody and everybody from any corner of the world can think of becoming an exporter or can get the imports done. And because unlike the earlier times, you need not take any serious type of permissions. You need not follow serious type of any protocols, because the real mandate is that the international market, every country will have to consider the player from other countries to be their own local player in their respective market, because there is only one concept in existence now, that is single global market. So when the entire economy or when the entire international society's activities, including the lawmaking process, is under the control or under the influence of World Trade Organization, and the intellectual property rights canopy of law is under tremendous influence of these economic forces or economic issues, because it goes without saying that intellectual property rights law is basically meant for promoting or adding value to the market economy. Intellectual property rights law canopy is basically meant for promoting and adding value to the market economy. It adds value to the manufacturers. It adds value to the producers. It adds value to the economic entrepreneurship. It rewards, it incentivizes the new innovative thoughts in the process of economic generation or revenue generation or market vibrancy, or adding more and more competitors into the market, ensuring more number of choices to the consumer. All this is perhaps promoted, incentivized, and rewarded through intellectual property rights law. Generally, and as well classically, people think that intellectual property rights law is basically meant for promoting innovation in the fields of science and technology, right? From various fields of science, ranging from physics, chemistry, and the material sciences, and to the life sciences, biotechnology, biochemistry, microbiology, etc. These science fields are best to be noted from the segment of intellectual property law. This is what people generally think, but it is not true. Intellectual property law is actually having 7 different areas within its ambit, and each and every area of intellectual property law is meant for promoting research and development in different areas, not only science and technology. Maximum patents may be for science and technology, but for other areas like humanities, arts, law, social sciences, you have different aspect of IPR or intellectual property that is there to promote your research and development. For instance, for the fields of trade and commerce, including economics, trade, commerce, and economics, we have trade secrets and we have trademarks. The 2 separate areas of intellectual property which talk about directly market regulation, which talk about promoting industry, which talk about ensuring consumers the right choice of goods and services and optimal utilization of those goods and services for the purpose of the benefit of the mankind. Similarly, for those people who are into arts and such other fields of languages, we have copyright law, which is meant to promote research and development in those segments. For the agrarian sciences, horticulture, sericulture, and the fields of disciplines of study and research, we have plant varieties law, which is supposed to encourage research and development in those areas. For the fields of engineering, civil, technical, architectural, or electronics, whatever, we have the fields of design, which encourages research and development in those fields of engineering technology. Like this, we have different compartments of intellectual property law, which drives research, development, innovation, creativity in different fields of science, technology, humanities, arts, and also law. So IPR, intellectual property law, is basically meant for promoting research and development towards industrialization, towards drawing market significance, towards adding value to the respective fields, driving those fields to generate market value. That's why we call it as trade-related aspects of intellectual property, economically driven platform of intellectual property. And that's the reason why among all the intellectual property rights that I mentioned with field specification like patents, copyrights, trademarks, designs, plant varieties, trade secrets, and also geographical indications, one striking point, one striking feature which puts all those segments together is economics. Because without economic viability, you cannot get patent. Without economic viability, you cannot enjoy your copyright. Without economic viability, you cannot get a trademark. Without economic viability, you cannot get your industrial design protection. Similarly with plant varieties. So whatever may be research that you are contemplating, whatever may be the research activity that you are trying to pursue in your respective fields of science, technology, arts, social sciences, humanities, etc., etc., if that research is not going to get you some economic value addition, economic viability, economic application, you are not going to get intellectual property rights, because it's all about driving the research to suit the economy, to promote economy, to add value to the existing economy. And how it can happen? When your research and development takes you towards market, takes you towards industry. When your research is having industrial demand, when your research is having market demand, that means it is having economic viability. It is having economic value. Only such type of research and developments in different disciplines gets encouraged, gets incentivized, gets rewarded through intellectual property rights law. So economic viability or economics is the driving force behind the entire gamut of intellectual property rights law. And that too, aftermath of the coming into being of the World Trade Organization as a briefed out, right, which has reduced entire world into single market. Anything and everything which is happening at any nook and corner of the world is having great impact on the entire world because of economics, because of the economic vibrancy, economic viability that is getting attached to that particular instance, activity, movement, whatsoever. Because now entire world is a single market. The entire world is a single market, and any corner of the world being part of the single market, if it is having any movement, any activity, that is going to impact the entire. Take for example, what is happening at Delhi and surroundings regarding farmers' agitation and all is having impact on your Bombay stock market. What happens in the Middle East, it will have impact on the stock market. What was happening during the tussle between Trump and Biden, it was having impact on stock market. The moment Biden took over, stock market started growing, right? Thousands of kilometers of distance, different types of democracies, different types of government, different types of people, right? Between USA, India, Middle East and all, but still your market is getting impacted because the world is a single market now, and whatever happens in whichever part of the world, whatever is growing, development taking place in whichever maybe the discipline, that is having impact on this global single market, and that is getting mapped through the lens of law. And that law is meant for not just regulation, but it is meant for governance. Regulation may be for prescribing some code of conduct and controlling your activity. That is a mere regulation. But we are here talking about governance, because governance is not just about prescribing code of conduct and regulating your activity, your economic activity, your industrial market activity, but as well ensuring governance. That means ensuring the interest, protection of interest of not only the market players, the actual market, the stakeholders in the market, and the recipients of this market economy, the consumers. So every single player or every single force, entity, individual who are going to have impact, influence, effect of the market will be ensured and assured that their interest will be protected. That is called governance, market governance. It's not just market regulation. We are talking about market governance. And for ensuring that market governance, intellectual property rights law is doing its best. How it can be, I will explain. For instance, now Serum Institute of Pune and Bharat Biotech Hyderabad, and as well another institute from Ahmedabad, happen to come out with COVID vaccines for the country, and India is now going under that COVID vaccine. We are trying to use it, and we are also exporting it. But the government of India assured that there can be no economics going to be involved in this vaccine. Otherwise, what would have happened? Serum Institute of Pune or Bharat Biotech would have earned crores, billions, and trillions of money from that by having intellectual property rights protection over that, by enjoying a patent over that. A single patent on this COVID vaccine would have fetched the serious world market to Bharat Biotech, because more than any other nation's vaccine, Indian vaccine is having great demand. India has already supplied vaccine to more than 20 countries, and in the times to come, India is going to supply the same vaccine to the entire world. Of course, at some price, some reasonable price for those people who are outside the country, but within the country, we are all getting it free of cost. No economics, no IPR, no patent. If there would have been patent on it, Bharat Biotech, as I said, would have owned the money which would have been equivalent to purchase entire India, because all the 215 nations are having the need of this vaccine, and India happened to come out with that in a very, very less duration of time with a very, very cost-effective way, and no, more or less, no side effects whatsoever, right? So if intellectual property rights law would have been given its way through, allowing Bharat Biotech, Serum Institute Pune, and the other institute at Ahmedabad to get their patent, they would have enjoyed economic rights, they would have enjoyed the market, world market in fact, and they would have enjoyed revenues. And all the consumers across the globe had to pay money to purchase that vaccine or to get that vaccine distribution whatsoever. But now what government of India is doing, keeping the health aspect right at the keeping the health matter in mind, government of India ensured that Bharat Biotech or Serum Institute would not enjoy any patent rights over that, and even government of India appealed the World Trade Organization, the real economic related boss of the world, to suspend intellectual property rights across the globe as far as the vaccine, not only relating to COVID, any pandemic like COVID. In case of any such pandemic, any drug, vaccine, capsule, tablet, injection, whatever, there should not be any economic generation, or there should not be any patent rights whatsoever on it. And few countries like South Africa joined India in echoing the same language to World Trade Organization, and World Trade Organization is also considering this. The point that I'm trying to put across is the other way around. Intellectual property rights law would have allowed these research laboratories like Bharat Biotech, Serum Institute, and all to enjoy their IPR patent rights, and they would have given the license to sell the same vaccine, COVID vaccine, to everybody around the world, and everybody would have allowed, of course, to enjoy the treatment, but at some cost. You never know what type of price they would have fixed, if not for our people, but other people. So mankind's health came into the activities of government of India, and because of that reason, now no economic viability is going to be assessed or mapped for whatever kind of vaccine that we are going to develop, especially for this kind of pandemic like vaccine. So patent law other way around, which is the IPR, intellectual property rights for all these science fields as I mentioned, including the field of virology, biochemistry, which have actually resulted their research, the research in the field of biochemistry and virology have actually resulted in this COVID vaccine. It would have not only incentivized, rewarded more and more amount of vaccine generation like this, but those laboratories would have enjoyed the market, giving them a lot of economic viability. But that is not happening because people's health is actually coming to the forefront than that of economic viability. Other way around, such a type of research and development, which are nothing but innovations trying to save the mankind's life and catering to the different health needs of the society, international society, would have given a lot of scope, opportunity for those research laboratories to enjoy their economic revenue generation. In fact, it is one among the different criteria of all the intellectual property rights that if your research activity is going to generate economic viability or economic revenue or market demand or industry demand, then only you are going to get IPR. People may say that it has to be novel, you have to contribute some new knowledge to the existing field, etc., etc. Yeah, they are there. They are technical reasons, but you have a market reason. That is economic viability. Sometimes it happens that we people end up with coming out with a very, very meritorious, academically centered innovation, top class, but no market, no industry, then no IPR, no patent. You cannot get into market at all without IPR. because nowadays taking entry into market is also under threat. You need to seal and you need to have the security and cover of either patent, trademark, or such other IPs to ensure that your entry into the market is safe and your existence in the market also safer. That happens through the stamping of government of India, saying that you are the patent owner, you are the trademark owner, or you are the design owner, or you are the copyright owner, whatever. With that stamping, when you enter the market, your market voyage journey will be secured, and as well aftermath of that, your standing existence in the market will also be very much secure. At the same time, ensuring that there is a free and fair competition in the market, and because of that, consumers would also get different options to avail of while exercising their choice to purchase or to avail the services as well. So economic viability is the real threshold, I can say, before you can obtain your patent. Any innovation, any product or any process that you come out with through your research in material sciences or your life sciences for that matter, like the one that I just mentioned, COVID, will have to have economic viability, market demand. Then only patent can be obtained by you. Similarly, your efforts in the fields of literature, language, or arts, right? It could be literary work, dramatic work, or architectural work, sound recording, musical, or cinematographic work, or any kind of artisanship, craftsmanship. That also, without any economic viability, in the sense there should be some publisher to publish your stuff, or there should be some producer to commission your work, or there should be some employer to give you employment and take through that work of arts, craftsmanship or artisan. Such kind of craftsmanship or artisan work is only allowed to get under the lens of copyright law, giving you life plus 60 years of protection. Patent law would give you 20 years of protection, 20 years of market presence, or 20 years of secured market you are going to get under patent law. But in case of copyright, life plus 60 years of market presence you will enjoy, because copyright law protected work, either the artisan work or craftsmanship work, literary work, right, writings, etc., will have market demand for minimum life plus 60 years. For instance, life of that individual whom you call as an artist, whom you call as a writer, author, or craftsman, and aftermath of the life of that individual, after his or her death, next 60 years, his or her kith and kin representatives, heirs will enjoy those rights. The greatest market presence, the greatest market demand, or greatest economic viability can be held, enjoyed, possessed by these types of intellectually protectable work like literary, artistic, dramatic, and such type of artisan work or craftsmanship. Here also, so market demand. Somebody should be there to commission your work, and aftermath of the work gets completed, somebody should be there to purchase it, or somebody should be there to exploit it. Especially in the cases of literary work, like you have written a book, it could be relating to market issues as well, or it could be relating to economic analysis of the law as well. Like Nobel laureate Amartya Sen happened to think over it and spoke about, happened to write about something which we are actually into now. He wrote that book some 30 years back. Probably it was about his one of his preliminary areas of research, right? And now we are seeing it through. And as well, people like P.V. Narasimha Rao, our late Prime Minister, happened to envisage this kind of euphoria in 1991 itself, and everybody scolded him, and people actually tried to throw him out of the seat of Prime Minister also. But today we are all thankful to these people, somebody who visualized it through his book Amartya Sen, and somebody who tried to implement it through open market, P.V. Narasimha Rao. So if it is that kind of writing, you have through publication or through market economic viability, you have different types of options open. You can translate the same into different language. You can convert the same into documentary. You can convert the same into a lecture. You can convert the same into a poem or a skit. Whatsoever, different types of options, market options are open for you if you are researching, or if you are trying to pursue research in the fields of these types of arts or artisan or craftsmanship like the kind of works. Similarly, when you are into trade, commerce, and economics, you are researching, you are trying to see the development of your discipline, especially trade, commerce, and economics. And are you actually trying to reach out to the market? You are trying to analyze the market. You are trying to make the market more free. You are trying to ensure that more and more number of market players are getting entry into the market. You want to make their voyage, their journey to the market to be smoother. You want to make their presence in the market to be safer. You want to ensure that consumers who are actually getting the benefit at the end of the day, getting the benefit from the market are not going to be duped, or you are trying to bestow on the part of the consumers the kind of knowledge, awareness with respect to reading the market, or are foreseeing the market dynamics. All these types of work you may be researching in from the fields of economics, trade, or commerce, or management. And such kind of research method that you actually try to come out with, or such kind of business planning, business strategy, or business method, whatever you call it as, and for which you are going to deploy people, forces into the market, and you are going to have that brand name, fame, right, goodwill, reputation, whatsoever. You are going to generate it for those entrepreneurs who are in the market, for whom you are working, or for those market players who are trying to make their presence more widely, more vividly present. And for that type of research persuasion, we have trademarks, which is nothing but a symbol of your business identity, symbol of your economic identity, symbol of your industrial identity, right? It is nothing but a tool to carry your name, fame, goodwill, reputation, right? Which is going to have again economic viability. You people know it better, people from the field of economics, trade, and commerce, that more than the cost value, your goodwill value gets attached to it. Sometimes the goodwill value will be more than the cost value, right? Cost value in the sense the actual value, actual money that you actually spent for making that particular product. Then more than that, your goodwill will be having more value. You take, for example, Coca-Cola and Pepsi. You all know that more than the manufacturing value of that Coke and Pepsi, the goodwill value is more, because it doesn't take more than 1 rupee to produce or manufacture that 200 ml of right, the Coke or Pepsi, but we are paying how much? 10, 15, 20 rupees, because of its brand existence, because of the market presence of the market share that Coke and Pepsi are enjoying, and also because of the celebrities who are actually endorsing it, all that. So that is brand value. That is the vibrancy of economic value. You are adding value to it, and then market forces are demanding that, because it's depending upon its vibrancy, its goodwill, name, fame, and reputation, consumers are buying it, right? Without goodwill getting attached to it, you cannot influence, you cannot attract the consumer. So more goodwill, more consumer. Less goodwill, less consumer. So at the end of the day, you are actually dictating, you are influencing the consumer choice through your goodwill, through your brand identity, through your great economic viability, great entrepreneurship qualities. So all that are getting rewarded, incentivized through the trademark law, through granting you a logo, through granting you a particular trademark, which may be your own name, which may be your own company name, or which may be a sign, symbol, or a particular alphabet, a particular numeral, a combination of alphabet and numeral, or a combination of color whatsoever, right? For example, you take PG, Procter and Gamble. PG is a trademark, right? You take Airtel, red and white combination, right? You take Intel, right? Number of such brands which are having their own carrying their own identity, right? So market identity, business identity, which is greatly influenced by the economic viability, more or less dictating the consumer choice. For such kind of your research endeavors, innovative endeavors, capturing the market, attracting the consumer, are bringing the producer, manufacturer, and the consumer together, right? Or are bridging that gap or bridge between a consumer and producer. Such type of efforts, you are getting trademark protection, brand recognition, economic viability related recognition, industrial recognition, right? Such kind of value addition getting mapped to trademark. So trademark for your research and development activities in these fields of economics, trade, and commerce, which are having great market significance. As I mentioned previously, if you are into engineering discipline, it may be civil engineering, electronics, electrical, or nowadays including your artificial intelligence, machine learning, right? All these types of engineering fields, whatever kind of research and development they actually indulge in, including the field of computers, software, electronics. You have a separate set of intellectual property rights law, which is called designs. Industrial design, nomenclature itself is there. Industrially viable designs are designs which are having industrial demand, market demand. In designs which are having economic viability. It could be design of your automobile, design of your two-wheeler, design of your four-wheeler, design of your mobile, design of your laptop, or design of any device which is controlled by software, which is influenced by electricity, or which runs not manually but through the help of machines. So such type of designs, engineering technology, if it is having economic viability, then only you will get IPR. So any design, any novel design, maybe belonging to the field of manufacturing, automobile, or computers, or software, or even electronics also, space related activities also. Any kind of engineering dream that you are trying to pursue, or any kind of research and development in the field of engineering, if it is devoid of economic value, if there is no economic value tag attached to it, you cannot get your intellectual property rights protection, that is design protection, right? So here also, in the field of engineering also, you ought to demonstrate, show that your research in your respective field of automobile engineering, civil engineering, computer engineering, or electronic engineering, whatever, it is having industrial demand, market demand, or it is having economic value or economic viability. Then only you can get protection. Now coming to the fields of our pharma related fields, agriculture, sericulture, horticulture, and things like that. Agrarian economy, whatever you call it as, right? The nomenclature itself is saying agrarian economy. There is a great demand that agriculture should be given the status of industry. Why? Because of economic reason. If it is an industry, you will get some incentives. If it is an industry, you will get some amount of promotion, like government is giving certain types of subsidy for medium scale, small scale, cottage industries. Such kind of benefit farmers also would get, because at the end of the day, it is a rural industry. If at all you give industry status to agriculture, where agriculture is taking place in the rural areas, so automatically that tag will come to it, because it is a rural industry. So the kind of benefits, incentives, whatever you are going to give to cottage industry, small scale industry, and medium scale industry would also be given to rural industries like agriculture. That's the reason why the farmers are demanding that. And when the moment you call it as industry, it is a economic value generation field. Of course, even now also, without getting that stamp of industry, agrarian world is serving the cause of more than 2/3 of the population. 2/3 of our people are actually dependent on agriculture. 2/3 of people are earning their livelihood through agriculture. They are earning money. That economic part of their life is dependent on agriculture. So 2/3 of our population, or 2/3 of India, is getting their economic value generation or economics of their life dependent on agriculture. And whatever may be the type of research that happens in the agrarian field, sericulture, horticulture, agriculture, and all. I'm not just talking about the research that takes place in the laboratory or university research institutes and all. Even the kind of natural research, human assisted research that takes place in the agrarian world, without having any formal technical knowledge or qualification accrued from college or universities. Such kind of research also. Sometimes our farmers do certain research and innovative activities by putting two plants together, or by following certain types of methods depending upon the weather condition, right? If there is a drought condition or less water, less rain condition, they will go for different types of cropping, or they will adopt different type of method. If there is sophisticated water facility, they will again go for different types of either crops, or the method they follow for that agriculture will be different. So they are innovative, they are creative in terms of whatever they're trying to pursue. So such type of research innovations, which are not just confined to the laboratories, but also in the agrarian field, to protect such kind of, to promote such kind of research, we have plant varieties law. That plant varieties law is meant for promoting research activity in the agrarian field, both formal and informal. Formal in the sense, typical research takes place in the laboratories through the people who have acquired technical knowledge, and informal that takes place actually in the in the cultivated lands without any formal technical qualification. So such type of research activity, whatever, if it is again coupled with economics, any new plant that you come out with, or any new sericulture plant or horticulture related plant or general agriculture related plant, if you are coming out with, if you want to have the stamp of intellectual property where there is market permission, typically you need to demonstrate that that plant variety, that botanical specimen, or that sericulture variety or horticulture crop, whatever you have come out with, is actually having industrial demand. For example, you take BT rice, BT cotton, BT soybean, BT brinjal, right? Everywhere across the world there is a demand for it. That's because it's a new variety, crop variety, through assistance of biotechnology, of course. But still, it's a new variety and having great demand. Why it is having great demand? Because of its own traits, abilities. You may consider even a basmati crop of India, basmati rice variety of India, which is having great demand across the globe, right? Because of its unique qualities whatsoever, right? So such type of research and innovations that takes place in these fields also having great intellectual property rights possibility because of its economic demand. So like this, different disciplines or different sectors, whatever you consider, there you can get intellectual property production only when there is presence of economic viability.
Professor?
Only when there is economic demand.
Professor, yes, sorry to disturb you. We request you to conclude by maybe another 5 minutes.
Sure.
Yeah.
So what I'm trying to put across is intellectual property law, which is basically meant for promoting research and development in general, as it is known classically. It is never a divide of economics. It is always driven by economics. You take patent law, you take copyright law, trademark, or whatever may be the areas of IPR that I happen to just touch upon, and having that correspondence with the different fields of science, technology, humanities, arts, social sciences, and all, without economic viability aspect, without industrial application aspect, without utility aspect, or broadly without the market significance, no intellectual property rights protection you are going to get. Patents, if they are not having utility, you are not going to get patent. If there is no publication or media presence aspect, you will not get copyright. If your goodwill, name, fame is not going to give you market enlargement or market vibrancy, you will not get a trademark. Your engineering efforts, if they are not having economic viability, you will not get design protection. Your agrarian or sericulture, horticulture related research endeavors are not having economic viability or market presence, then also you are not going to get intellectual property rights. So ultimately, what I'm trying to say is, in the economics driven world, especially aftermath of the coming into being of a World Trade Organization, maybe from January 1995, entire lawmaking aspect, not only intellectual property rights I'm talking about, any law, corporate law, consumer law, competition law, different types of commercial laws are completely driven by the economic aspect, right? Even the human rights related laws also, environment related laws also, now there is some economic aspect getting involved in that, because ultimately nowadays law is meant for not regulation but governance. In the overall governance aspect, giving that ensuring that livelihood, giving that economic viability aspect, because ultimately it is going to give you staple food, it is going to give you that capacity to earn your staple food, earn your livelihood, right? Livelihood is measured now, and people's capacity to purchase what they need for their livelihood is dependent on the economic status, whatever they are having. So ultimately life is dependent on economics. That's the reason why the lawmaking process nowadays is significantly driven by economic aspect, and intellectual property law rights law is a great example in that regard. So we are living in the economics driven world now, and that's the reason why the lawmaking process is also completely, if not completely, at least substantially driven by economic viability aspect or economic forces. I thank the Department of Economics, University of Mysore, for giving me this opportunity to share my thoughts on this aspect of law and economics interface, especially from the perspective of intellectual property rights law. Thank you. Thank you very much.
Mute ಮಾಡಿವ್ರಿ. Now I request Professor T.S. Somshekar, Professor of Economics, National Law School of India University, to speak.
Good evening, everyone. And it's a pleasure to be here today, virtually, of course. I must state that although I did my PhD in the Institute for Socio-Economic Change, we know that Mysore University is the PhD granting university. So you could say that I'm an alumni of Mysore University too. So I would like to thank you all for inviting me here today. It's a pleasure to speak here, and it is also a pleasure to listen to my colleague, Srinivasulu, some fascinating aspects of IP. There are a lot of IP and competition law interrelated issues as well. So thank you for inviting me here. Let me proceed with this particular topic. So I'm dealing with mobile ecosystem and competition law in India. So let me just start by speaking a little bit on law and economics. So as already pointed out by Professor Srinivasulu, law and economics is not just the application of economics to economic laws, like say, for instance, securities law or competition law or trade law, but it's also spreads across to other areas of law. It could be tort law, contract law. It could also be family law. It could be a law of crime. So it simply spreads across, and there are many ways in which these two disciplines stand to gain by learning from each other. So having said that, let me proceed to now the application of economics to competition law. So competition law by nature is an economic law. The purpose of competition law is to ensure that firms do not engage in anti-competitive acts. All right. So what are these anti-competitive acts? Broadly speaking, you can categorize them as agreements which are intended to subvert competition. And what are these kinds of agreements? One example is cartels. All right. So cartels are an example of horizontal agreements, firms producing competing products, getting together to act like a monopoly, manipulate the prices, manipulate the market share. Now, this obviously leads to a detrimental situation for consumers because cartels, as you all know, would lead to a situation where prices would increase and the quantum of output would reduce, right? Now, the next category is the abuse of dominance. So abuse of dominance is where a firm is so big and it has so much of market power that it can act independently of competitive pressure. Okay. And then the next one is mergers. So when firms merge, what happens is they could become so large that they could also become a dominant firm and therefore act like a dominant firm to the detriment of consumers. Now, I keep saying consumers because although competition law or antitrust law across the world is concerned with market efficiency, predominantly their interest is consumer welfare. So it is by that yardstick that they always assess mergers or assess, any acts of abuse of dominance or any agreements that lead to what you call as appreciable adverse effect on competition. All right. So all of this is found in the Competition Act of India. So the Competition Commission of India itself came into the picture in 2009. All right. And the enforcement of the Competition Act is being done by the Competition Commission of India. So having said that, now let's move on. So what is the mobile ecosystem? Now, if you say broadly speaking, the mobile ecosystem consists of everything necessary for us to use a smartphone. So I'm talking about a smartphone, right? So what does a smartphone need? You need a handset, you need the operating system, and you need the apps that go along with it, right? So all of these come in a package. Now, what's happening in this ecosystem? Now, if you look at this ecosystem, right, uh, we see in India predominantly what you see is that there are two players. All right. So who are these two players? You essentially you have various smartphone manufacturers, of course. If you look at smartphone manufacturers, there's a lot of intense competition between smartphone manufacturers like Samsung, Xiaomi, and all of these. And they compete. There are different, relevant markets, you could say, in smartphones as well. You have the lower end smartphones, you have the mid end, and then you have the high end, right? So in the high end, you have Apple being very dominant, and Apple's operating system is the iOS. And there, Google is also operating there. Google has its own phone there with the Android operating system. And in the lower end, you have predominantly Android-based operating system smartphones. Google and Android, operating system, as you all know, is Google's operating system, to say in a simple manner. All right. Now, on the one hand, you have intense competition between smartphone manufacturers. All right. So in the downstream market, there is intense competition between these smartphones. But when you come to the operating system, if you have a look at the market share globally, in January 2012, for instance, the market share was something like Android operating system had something like 23.21%. And Apple had something like 24.02, right? However, gradually, this has changed. By October 2020, it became 79.92 in favor of Android and 26.53 in favor of iOS. All the remaining players were knocked out. Windows, Symbian, BlackBerry, and all of them got completely knocked out. All right. In the case of India, the market share of Google's Android has been fairly consistent since 2012. It's been about mid 90s percentage. Okay, so currently it's about around 95%, and iOS is about 3.34%. All right. Now, why am I, speaking about market share? It's very important that we understand market share. Now, we have about 700 million smartphone users in India, all right? And, and most of them use the internet as well. So that is a phenomenal market, all right? Now, what have we established so far? There are just two players, okay? There's Apple iOS and there's Google's Android used for smartphones. Now, now we know in economics, we say that in oligopoly, it's quite possible, even though you have few firms, that there can be intense competition, right? But at the same time, an oligopolistic structure can, and there are various other features necessary as well, can also facilitate, cartel-like behavior. Now, the question is whether here in this market, these two operating systems are competing with each other, and whether one is, giving in sufficient amount of competitive pressure to the other. Now, what are the various factors which help us to understand whether Google is facing competitive restraints from Apple's iOS? Now, firstly, Google has had a strong market share of about 95%, above 90% since 2012. So it has had a very steady market share. Now, in the Competition Act, we mentioned three things, right? So we said cartels, abuse of dominance, and mergers. Now we're dealing with abuse of dominance related issues in the smartphone market, right? So what's happening here is Google's market share is so huge that it actually faces no competitive restraints. Now, however, market share itself is not a sufficient factor to help establish dominance. It is a screening mechanism. So competition authorities across the world will use market share as a screening mechanism to establish at the first stage whether a firm has dominance. And then it looks at other factors. Now, if you have to look at market share, then the question is, what market are we talking about, right? So the concept of relevant market comes into the picture here. Now, relevant market in antitrust or competition law is slightly different from relevant market in the case of general economics defined markets. So what is a relevant market here? Well, if you look at cases across, some of the most famous cases against Google, EU levied in 2018, EU levied a fine of about 4.3 billion euros on Google. All right. And related to its Android operating system. And it clearly defined the relevant market as the operating system itself and the market for apps. All right. So there are different markets over here, but the operating system itself is a market, right? So here you just have two operating systems. And again, the CCI is also investigating Google it's initiated investigations into Google's Android operating system for potential abuses of dominance. So the first step that we're going to do is define the relevant market. So in the case of EU, as well as with respect to India, the CCI seems to have accepted the operating system as one relevant market. Okay, so now in this relevant market, Google has a market share above 90%. That's a large market share. But then this large market share itself, need not be an indicator, because although it has a large market share, there are two things that we got to look at: competition within the market and competition for the market. Competition within the market is players within the market who are competing. So there are only two operating systems here: Google's Android and Apple's iOS. Apple's iOS is a closed system. Google's Android is an open source system. People can use the Android, develop upon it, and use it for their own smartphones if they want to, right? So now here there are just two players in this market for operating system. Now let's look at the other factors and see if whether the other factors also sufficiently add up to say that Google is dominant. Now, what are the other factors you got to look at? One is a stable market share. Since, if you look at from 2012, I'm just using that as an indicator, its market share has been steadily in the 90s, all right, no displacement, right? Now, the next factor is to look at Google as an enterprise, economic enterprise, and look at its economic strength. Now, Google's profits are something to the tune of $180 odd billion. And I'm stating the statistics of 2018, that too, right? That's phenomenal amount of resources, right? Now, what are the factors? Is there potential competition? Can someone quickly come and take away Google's market share? Now, let me give an indication as to what this potential competition can actually mean. Now, recently, of course, Elon Musk, tweeted or did something of that sort or through a messenger saying that shift to Signal. And the moment he said that, several people got out of WhatsApp because WhatsApp was changing its privacy policy, and they shifted to Signal or Telegram. Now, a huge millions and millions of people began to shift out, right? So what happens is that even though there are smaller players within the market, very quickly they can acquire a large extent of the market. And if it's also possible for some new entrant to suddenly come into the market, just because the situation changes in this market, a new entrant could very quickly enter into the market and steal a large percentage of the market share. That is potential competition or competition for the market. In the case of Google's Android operating system, it's unlikely that any other potential competitor could easily attend. Why? Because the development of this operating system involves enormous amount of sunk costs, huge amount of R&D expenditure. And not just that, you also got to develop one more critical factor. And that is what you call as network effects, right? Now, Google's Android operating system is like a platform. So we speak of platform economics, right? So what is a platform? It's an interface between, there are several, players around this platform, okay? It's a multi-sided platform, as we can call it. There are advertisers, there are app makers, there are users, and then of course there is the smartphone manufacturers themselves who want to use this operating system. All right, so it's a platform which has multiple sides to it. Now, it also has network effects, indirect network effects. What are these indirect network effects? Why am I speaking of network effects? Because these network effects further reinforce Google's dominance or market power. So what is this network effect? Let's say, for instance, the number of users of Google's Android increases. Okay, the number of if smartphone manufacturers have adopted Android and more people prefer to buy smartphones with Android operating system, then what happens? App developers would also prefer to develop apps for Google's operating system, right? So if there are more and more apps available for Google's operating system, well, more and more users would also prefer to use Google's Android operating system based smartphones, simply because there are more apps available. All right, of course, there is a limit to how many apps we can use, but we all have our preferences, right? So there is one indirect network effect. Now, if you want, so what's happening here is that all these factors, Google's economic strength, presence of network effects, and also the fact that there are huge sunk costs necessary to enter into the market, and it's established markets. All of these can quite clearly establish that Google is a dominant player in the market for operating systems. While Google is one of the players in the ultra, priced smartphone markets, in the rest of the segment, Google is the dominant player. There's no other operating system which can displace Google in the operating system market in India. So literally, Google becomes a gatekeeper. All right, it determines if you want to enter into my operating system, I decide what you got to do. So, having established that Google has got market power, which of course the Competition Commission will be examining in its cases, and that's what the European Competition Commission has also found. Now, if Google has this kind of market power or dominance, now the next question is Google abusing this dominance? All right. So the European Competition Commission has said that, well, Apple's iOS does not have any sufficient competitive restraint on Google and Google's Android operating system. And the Competition Commission of India is also inclined to think in a similar fashion. Right? Now, so Google's dominant. Hypothetically, let's proceed now. So the whole purpose of this journey is to understand if the present construct of the market is such that it allows for greater efficiency, both static efficiency as well as dynamic efficiency. By dynamic efficiency, I mean to say innovation, right? So now let's have a look if Google has abused its dominance. And I'm not saying it has abused, but let's see. We got to discover this for ourselves. And the CCI is going to be actively looking into this. So in what way can Google actually abuse its dominance? We can divide abuse of dominance into two different types. One is exclusionary abuse of dominance, and the second one is excess or exploitative abuse of dominance. So under exclusionary abuse of dominance, Google, by virtue, what Google does is, because it's this dominating operating system, and smartphone manufacturers, if they want to sell smartphones in India, they have no other option but to use Google's Android operating system. Now there are other versions of the operating system, all right, which you can, it's open source, you can use it, and you can try and develop upon it and try to build upon it. But the problem is, no, Samsung did try that. But unfortunately, what happens, the network effects come into play. If app developers have to develop apps for another platform, now that involves significant amount of costs. So that's the whole reason why they prefer to jump onto a bandwagon, a network that is already large, because for them, you can develop it at a certain cost and reach a wider market. Now, if Samsung comes up with a different operating system, or someone else uses the open source operating system and develops upon it, now for these app manufacturers, app makers to develop apps for that operating system, it incurs a cost. Now, however, they have a very small market. So they will say it simply doesn't make any sense. Why will I spend a significant amount of resources to develop this app for this other Android operating system, which has a very small market? Doesn't make sense. So the network effects prevents new operating systems, even Android based, from competing with Google's Android system. Now, at the same time, let's be very clear. Google spends a huge amount of money on innovation, and the services that it provides to app developers is enormous. There's a substantial amount of innovation that comes with it. But the question here is a counterfactual question. The question is whether we could be better, even better off, if there was competition. Let me give you an example. Now, sometime back, there was no Geo in the market, right? And recall how much we used to pay for our phone calls as well as for data. Now, the moment Geo entered into the market, you have seen intense competition. Now, you can have a big discussion as to whether Geo was predatory pricing and so on. But the point is that it led to an enormous amount of fall in the price of data such that you and I can right now sit across this particular platform and have an online discussion. This perhaps might not have been possible if not for data charges coming crashing down. So the point is, competition enabled us to get access to these resources in a cheaper manner. So here the question is a counterfactual question. Can we be better off if we had competition? Right? Now we can't blame Google for having becoming big. Being big is not bad. The question is whether are you big and are you trying to ensure that you continue to remain big by preventing potential competitors from entering into the market? That is what is an abuse of dominance. Okay. So here, what is Google doing? We were discussing, exclusionary practices, right? So Google, because of its dominance in this market, now what it does is it insists that smartphone manufacturers have to pre-install its apps. That is a part of its agreement. So what are these apps? Google's proprietary apps, Google search engine, Google Chrome, Google Maps, YouTube, all right? And most importantly, Play Store, through which you download all your apps. So Google insists that you must, get into all of this. And that's what Google was hauled up for in Europe as well. In US too, now all these tech companies are being investigated. But that's what it insists. Now the question is, why should I? If I'm a smartphone manufacturer, why should I download it? Now this is where platform economics comes in. And we must not ignore this while studying Google's business model. Now Google says, all right, you take my operating system for free. Don't pay me anything. But you must pre-install my apps. Right? So what happens in a platform, right? One side of the platform users may be heavily subsidized and the other side is charged a higher price. And that actually is a profit maximizing strategy. So it's not at all a problem. Right? So for instance, in internet searches, we as users of the internet, we don't pay anything. But there are others who pay, those who advertise on the internet. That's the reason why we also get a newspapers at a very cheap price, because there are advertisements in the newspapers. So we have to understand this platform economics before we take a call. So Google's model is, I give you the operating system. We spend a lot of money on its R&D, and this operating system will make your handphone, this handset, to work fantastically. There are several things that the operating system can deliver on. It reduces, it extends your battery life. It may prevent heating. It may make your apps work faster. So it's very critical for any smartphone manufacturer to have a really good operating system, because the functionality, you may have a tremendous, amount of hardware put into it, but that hardware to operate well has to have a good operating system. So a good operating system based on Google's R&D and also another network effects. What is that? Once Google gets more and more and more data, I'm now coming to data as another barrier to entry. I just spoke about network effects as a barrier to entry. Now I'm coming to data as a barrier to entry. Now Google gets an enormous amount of data through your searches, through your app behavior. It has all this data. Through that mechanism, Google is able to constantly improve upon its product. And that makes it even more difficult for some new operating system to come and challenge Google. Now, given all of this, Google already seems to be, Google's accused of abusing its dominance by saying, we will only, you can only use the Play Store. In some senses, it has acted in this exclusionary manner by saying that you can only install this Play Store. And it has also said you cannot install, alternate versions of Android either. All right, it has insisted upon handset manufacturers that if you want an operating system, you cannot install an alternate Android-based operating system. All right. Now, so therefore, firstly, it insists that its suite of apps must be installed. Now, what's the big deal? Right? What's the big deal? It's all right. You install these apps and you install the other apps as well. Right? Now, there are a couple of you sitting over here. Can I ask you all a question? Okay, so it's an active participation question. How many of you are right-handed? Can you please raise your hand and tell me how many of you are right-handed over here? Right? Now, please look around yourself. all of you who are right-handed, lifted your right hand to indicate you're right-handed. Right? Now, this is what you call as something which we do by sheer habit. Right? By sheer habit, we have certain preferences. By sheer habit, we'll press Play Store. If you look at your Samsung phone, you'll find Samsung Play Store and you'll find Google Play Store. You'll just click Google. One, because of brand, and maybe you believe quality, of course, plays a role. And then it becomes a sheer habit. The second thing is what you call as a status quo bias. Now, why do we use Google search engine? We use Google search engine because we like it. And could there be something better? Possibly. But inherently, this is the contribution of behavioral economics to this entire process. Inherently, we don't want to. We are lazy. We don't want to. All right, so we don't. So when you install these apps over here, there's a very high chance that people will use these apps and will not go to other apps. Right? And in fact, 90% of the apps are downloaded through Google's Play Store. Now, that is Play Store, excluding other versions of app stores. Okay. Now, the next exclusionary behavior. You would have heard recently how Paytm was chucked out of Google's Play Store. Why? For certain reasons. Google said that, Paytm was abusing certain, certain principles that it had set out. Okay, security measures and privacy measures and whatever. It's perfectly fine. Google is entitled to do that. In fact, if Google did not, go into that, we might as well have said that we would have probably blamed Google for that. Said, look, it's your operating system. You should ensure that we have safe apps. So Google is right in doing that. But the problem here is that Google is also a competitor with Paytm. Google has its own payment app, Google Pay. Now look at how data and asymmetric information plays a role here. Now, I don't know what information Google has about Paytm. Now, Google, through its data analytics, could possibly know that Paytm is its closest competitor, right? And it could, for instance, does it have enough data to say that if you were to keep Paytm out for a month, hypothetically speaking, I'm not saying it's true, then most of these people who are using Paytm will shift to Google Pay. Now, that kind of a shift, what happens, then you build that upon with your status quo bias, you will refuse to shift back. So I'm coming to another term over here now, what is called as switching costs. Now, you may have a network, but if you can easily shift out of the network with low transaction costs, then it's not a big deal. The network should not offer a big deal in the sense that you're using Google Pay today, where it's very easy to shift to Paytm. You'll download it and you'll use it. So easy switching costs should mean that that's not a big deal. All right, Google faces competitive restraints in the payments app. But build it together with this behavioral aspect of status quo bias, it may not really be so. Once you displace one player and you continue to build up upon it, how does Google build up upon it? It provides you plenty of rewards, incentives. Now that kind of cash burn may not be possible for Paytm. It may not be economically strong enough to do that. All right. Now, these are all aspects that need to be looked into. I'm not yet saying that Google has abused dominance, but there are very interesting aspects that come up here. So I've dealt with I've dealt with exclusionary practices, okay, abusive dominance. Now I'll come to exploitative. Now, how does Google make its revenue? $184 billion, more than $200 billion, let's say now. Most of its money comes through advertisements. Now, Google seized upon the opportunity way back in mid-2000s. It realized that the future would be internet searches through the smartphone. And that's why it bought out the Android operating system, right? So it brought out the Android operating system, developed upon it, and today it is true. Most of us, spend enormous amount of time on our smartphones searching the web. And therefore, Google is able to provide ads, targeted ads, and make money through that. That's where Google gets most of its money from. You could say about 80% of its revenue comes through ads, right? And some more amount of money that comes in through in-app purchases. What are in-app purchases? when people buy apps, or when they want to, through an app, let's say you have some gaming app, and through this gaming app, you want to buy something to continue playing. Now, in that case, you're charged about 30%. The app developers who sell these to customers have to pay 30% of their revenue to Google. And then I think after the first year is 30%, and then it drops to 15%. Now the question is this price for in-app purchases, is this too high? Is this exploitative? All right. Is it resulting in a situation where the app developers cannot pay this amount of money and therefore have to drop out? Now, if that happens, then if there's a competing Google app, then Google prevails. But the key point is that price exploitative? Now, of course, to say that is exploitative, we need to establish what is a competitive price. Now, the competitor for Google is Apple. Now, very interestingly, both Google and Apple have the same types of prices in the US. 30% in the first year, and then they drop it down to 15%. And when antitrust investigations were threatened, that's when they dropped the prices apparently. So therefore, the key point here is what is actually a competitive price. All right. So there are several other ways in which I can go ahead to speak about exclusionary and exploitative practices. So in this mobile ecosystem, the key question is, do we have sufficient competition to ensure greater amount of benefits for the consumers? Right? That is a key question to be asked. We know that competition delivers better, right? Now the question therefore here is whether competition is being subverted. Now, any attempt to maintain your dominance through exploitative or to abuse your dominance by using exploitative practices, or to maintain your dominance through exclusionary practices can mean reduction of competition through anti-competitive methods. And if competition is good for both static welfare as well as for dynamic welfare or dynamic efficiency, then the counterfactual becomes very important. All right. Can we be better off? Should we have more competition in the ecosystem? But then the danger is, if you were to say that don't insist that they must use their operating system, let anyone use their own operating system, let anyone use their own app store downloading mechanisms, then the question also is whether they would be credible, reliable. All right. So there is this other aspect as well. So I stop at this point and we're open to questions. Thank you. Just before I leave, let me just share my screen and I'll show you something. A practical demonstration, a small example. All right. Okay, so I'm sharing my Google screen.
Yes,
and
yes.
I'm going to type in, I want to fly to Delhi. Bangalore to Delhi, right? This is of course not related to the mobile ecosystem. So look at my screen here. What do I get here? I get 1, 2, 3, 4 different options for me to book my flight. And look at all of these. These are all ads. So the first few are all ads. Perfectly fine. So if you pay for an ad, you get placed there. Similarly, in Google Play Store, if you want to download an app, if you are an app developer, a small app developer, if you want to get your app downloaded, you got to be among the top apps to get it downloaded. So what if you're not in the top apps? Then advertise on Google platform, on Google search. Now that becomes very expensive for small app developers. But then of course you could say, well, that's how the game is played. All right. But then have a look at this. All these ads are done. And then what is this?
Right.
Right. Now, guess whom this is coming from? The very first general search. Now, this is Google's flight search engine. And then come the other, make my trip. So, this is what Google was hauled up for earlier, that is manipulating its search engine. All right. So by manipulating its search engine, Google is able to put its own apps, its own portals above its competitors. Now, this is what is problematic. All right. So thank you very much.
Very good. Yes, now it is a question hour. Participants, they can ask or get clarifications from the experts. When you ask any question, it should be specific and very clear, and you should name the person whom you are going to question the get clarification your what is that issue. Thank you. Now it is open for participants.
There are some questions on the chat. I don't know if
Okay.
there are so many chats. I really don't know what. I I, I see one on the chat. They're all about data related issues, but they say that we are losing personal data. Are we safe from these apps? Cartelization of data by big tech companies and threat to national sovereignty. Well, yes, big data, as we call it, big data is essentially means, there are certain features which characterizes big data: volume, velocity, veracity, and variety. You call them as the different V's, right? So for instance, if you have your smartphone and you're traveling in your car, even if you turn off your smartphone, there's a lot of data that's being emitted, your location data. Okay, your phone pings, every now and then, maybe a Wi-Fi or some other particular digital device which can read your device. So Google can easily trace where you're traveling. If you go to your Google settings and if you look at it and if you look for where you've traveled, you'll actually get all your data about where all you've been, maybe for the past couple of years, right? Now the question is, how does Google use some of this data? For instance, it's used for Google's own innovative services. For instance, when you have your smartphone and you travel, Google is able to calculate, on Google Maps, when people want to travel from one place to another place, it's able to calculate and tell you how long it will take you to reach from point A to point B, because of its ability to, understand all these smartphones along the way, the speed with which they have been moving. It's able to easily give you that distance. All right. So there are wonderful ways in which Google uses this data to deliver very innovative services. But at the same time, you must understand that when you're giving up this data, you think you're using the internet free. But as we as economists, we say there's no such thing as a free lunch. So when you use the internet, the price is yourself. You are the product. All right. It is you, your personal information, your searches. This is the kind of information that is used by companies to deliver services to you. Now we have absolutely no clue what kind of data is being used. If you came to know that if your phone is switched off and still transmits data, it can be scary. Now let me give you some ridiculous examples as to what things happen. Now, if your phone can be voice operated, I mean, in the sense that you can, you speak to Siri, or you speak to, all the cousins of Siri. All right. So it means it's listening to you, right? It's listening to you. Now, where the hell is all the speech, is all this conversation of mine, in at my house or wherever it is going to? Can that be accessed? Right. So privacy issues are enormous, right? So yes, privacy issues, should they be a part of competition law, is being much discussed. The government of India is looking into localizing data and whether data should be shared with smaller enterprises, because if data becomes a huge barrier to entry, then should these companies be made to share some of this kind of data so that other firms can use it to develop? Remember, when we speak in a macroeconomic perspective, if we want sustained economic growth, innovation is very key for us. And that's where we're ahead of China. So if you look at the innovation that is happening now, there's a huge amount of innovation that's happening in the internet ecosystem. Now, that internet ecosystem, if it is dominated by one firm, can that lead to a reduction in the rate at which innovation can turn up? Can many innovators find it difficult to actually break through this gate and have the innovative product come up? So that becomes another problem, right? So therefore, the government is looking at data. I'm not saying whether that's correct or not, but many discussions that are taking place right now.
Any questions? Okay. If there are no questions, I have small clarification with Professor Srinivasulu. Professor Srinivasulu?
Yes, sir. Please go ahead.
Yeah. Yeah. See, we heard and also we read in the newspapers, America will be like hijacking the patent rights of neem and turmeric, all these things. Basically, they are from India. So how easily America can hijack in the name of intellectual property rights, patent rights, or whatever? Just some clarification, if it is possible, it will be nice. Thank you.
Yeah. Not only neem and turmeric, even the same thing happened with basmati also.
Right. Yes.
Yeah, there are about 50 odd patents granted on these stuff of India, especially which is called as India's traditional knowledge, India's heritage, or biological diversity. We call it as. There are about or around 50 patents on various applications and use of neem and turmeric. What is happening is by using the original neem and turmeric, they are going for genetic engineering of the same. They are trying to modify it, like it happened with the basmati. We happened to fight a case with USA before international organizations and won it. In 1996, what happened? USA happened to obtain, USA Patent Office happened to give basmati rice related patent to one of the American rice companies, American rice tech company, it is called as. But and when India realized in 1998, it happened to file a case before WTO, the same organization which I have been talking about, and happened to uh, happened to fight it before that organization, saying that it has been India's heritage. It is grown in India and Pakistan also since centuries. How come you have granted a patent? Then the response was, we have not granted patent on basmati. We have granted a patent on the modified version of basmati, and it is titled as Texmati. Why they titled similarly? Because they wanted to reap confuse consumers and reap profits. But going from the lens of research and development, what America happened to do is not a wrong, because they have improvised the basmati rice variety, and they have gone about coming out with a new and innovative variety. What the fault is that you have taken the samples from India, and you have not acknowledged India. You have not acknowledged the people of India's contribution in conserving that basmati rice variety since ages. And you should have shared 50% of the benefits with India. This is the law now. You can also, we can also go to Amazon forest in USA and collect any samples, right? And come back and engineer it and go for the improved version. But you have to pay back the half of the stuff, half of your economic your revenue generation, whatever you have done to that Amazon forest people. That's the law across the world internationally. But America happened to do that. And in 1999, we happened to get it revoked. And aftermath of that only, we happened to bring out geographical indications law in India. That law's purpose is to, as you mentioned, all those traditionally rich products like neem, turmeric, basmati, or Mysore pak, Mysore sari, Dharwad peda, right? All these types of traditional products we have documented, mapped, and now all those things are forming part of even Google searchable public domain. So that, because intellectual property law always talks about a new thing, something new. So the moment now you go about doing something with the neem, Google will give you information that neem is having this much of information and it is coming from India. Same will happen with basmati. So till 2003, when our geographical indications law, which is a sphere of intellectual property law, happened to come to the forefront, till that time all these things happen. All those two things that you mentioned, neem and turmeric pirating, neem and turmeric misuse, neem and turmeric related patents, all that happened during 90s. And aftermath of that, we happened to bring out not only legislation, but we have made enough legal mechanism available to stop all that now. That's the reason why now across the country, we are actually documenting all traditional products. At every district level, there is a biological diversity authority whose job is to document Indian traditional knowledge, Indian traditional products. like I mentioned, Mysore saris, Mysore Pak, right? All that. Because of that, now there is no scope for any of the foreign companies or anybody for that matter, any industry for that matter, to pirate Indian traditional stuff, because traditional knowledge is beyond, outside the purview of intellectual property rights.
Thank you. Any other question? Okay. In that case, if there are no other questions, now I request Professor Mahesh to propose vote of thanks. Professor Mahesh.
Honorable resource persons, the esteemed faculty members of our department, and all dear participants of this national seminar on web seminar on law and economics. So it is my privilege and also honor to propose vote of thanks for the august body of this webinar. Firstly, I extend or warm cordially thanks to Professor Hemant Kumar sir and Professor R. Sivappa sir and their absence being supportive for conducting these kinds of webinars in the department. On behalf of the Department of Economics and Cooperation, I extend our heartfelt thanks to our Vice Chancellor sir and also the Registrar sir. We also extend our heartfelt thanks to Professor N.S. Srinivasalu sir, the Professor of Law, National University of Judicial Sciences, Kolkata, for accepting our invitation and presented a informative and knowledgeable lecture on economic analysis of intellectual property rights. On behalf of the Department of Economics and Cooperation and University of Mysore, I extend a heartfelt thanks to you, sir.
Thank you, one and all.
Also, I extend thanks to Dr. T.S. Somshekar, sir, Professor of Economics, National Law School of Indian University, Bengaluru, for sharing his valuable knowledge on mobile ecosystem and competition law in India. Sir, your lecture is highly knowledgeable, effective, and also informative. So on behalf of the University of Mysore and Department of Economics and Cooperation and my own behalf, on behalf of all the participants of this webinar, so we extend a heartfelt thanks to you, sir. And also I extend our thanks to Professor Indumati Madam, the former Vice Chancellor of Davangere University, being a part of this webinar. Thank you, ma'am. And also I extend our thanks to Professor Gopalappa sir, the chairman of our department, and the coordinator of this webinar, Dr. Navita Madam, and Dinesh sir, SM Basuraju sir, and all my junior faculty members. And also I thankful to all the participants who are participated in this webinar. And also we extend our thanks to media persons and also UPE staff members. So once again, I thank you, one and all. Thank you very much.
Okay, we will end the session now. Thank you.
Thank you all.
Thank you.
Thank you very much.
Thank you, everybody. Thank you.
Thank you.
Thank you.
Thank you. Calling from today.
Yeah, thank you, ma'am. Thank you.
Thank you very much.
Thank you,
everyone. Thank you so
thank
much.
you, everyone.
Thank
Sir,
you, sir.
feedback
Very
link, sir.
informative sessions, webinar, sir.
Very good. Thank you.
Sir, we wanted to know where the feedback link is being.
Thank you, madam. One and all. Thank you.
Thank you.
Thank you. Thank you. It is in the chat box.
Thank you, sir.
Thank you, May, sir. Thank you, sir.
Meeting end video and feedback form.
Right. Yeah, I announcement.
To all the participants, a feedback link is provided in the chat. Kindly go through. Share it. We are sharing it again.
Thank you, ma'am. Hello, ma'am. So good to
Yeah.
see you all. Indumati madam, Navita madam,
Thank you. Thank you.
Gopalappa sir,
Thank
and
you.
Mahesh sir. So good to see all of you.
Thank you, Tenzin.
And Dinesh sir
Thank you,
also is there.
everyone.
Thank you. Thank you so much. So good to see
Yeah.
all my teachers.
Yes, good, Tenzin.
Yes,
You are
ma'am.
back into academics. Nice to see
Sure,
you
sure,
also.
ma'am. Yeah, thank you so much. Yeah,
Yeah,
it was a
thank-
wonderful session. Thank you.
Thank you.
Okay, right.